Do you remember DUI? I mean, SUI guy? No? Well, here, let me refresh your memory. Or come back in about 40 minutes for the new stuff.
So imagine this scenario. I'm sure most of us have probably been there once or twice in our life. It's Saturday night. You're out with your friends. You're having a fabulous time. Drinks are flowing. Music's going. Shots, 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 shots. And before you know it, you've had a few too many. You didn't mean to. You were planning on driving home yourself. But things happen. So you have choices. You could be that guy. Go ahead and drive home. You could find someone at the bar. You know, beer goggles and all. But you wore your bikinis. It's not that sexy. So you go to your phone. Who can you call? You try to call a friend, but your phone's dead. So you schlep over to your car to charge your phone, except it's 20 degrees outside and you're freezing your ass off. So you start the car up to turn the heat on and wait for your phone to charge. And you pass out. I mean, something similar has happened, right? So you sleep it off and drive home when you're able to. But is that legal?
Branson Hoffman versus KDR, 23 CV 42, announce appearances.
May it please the court, Your Honor, Mackenzie McCoy on behalf of the petitioner, Branson Hoffman, who also appears via Zoom.
Charles Bradley for defending, Your Honor.
Mr. Hoffman, to appear, I'm going to need to see you on the video, please, to make sure. There we go. Very good. Thank you. All right. We are on today on the petition for review filed by the plaintiff from the earlier hearing. Are we ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
Okay. Ms. McCoy, as I understand the issues raised at the administrative hearing, I'm not exactly sure, but it appears the allegation is your client was asleep in a car with the engine running in a parking lot, correct?
Correct, Your Honor.
Okay, and what are the, as a result of that, what are the particular issues that you want the court to note?
Your Honor, our particular issue up for today is that there is no reasonable grounds or probable cause that existed at the time to believe that Branson Hoffman was operating or attempting to operate the vehicle while under the influence.
Okay. Anticipating that, I did some research regarding that issue, not limited, of course, to this research, but I read State v. Kendall, which cites State v. Kendall 274 can 1003, which cites State versus Fish 228 can 204. I also read, maybe more importantly, State v. Darrow 304 Kansas 710, which cites an unpublished Court of Appeals opinion, State v. Sprague, which is 2012 WL 3822625, a 2012 case. Mr. Bradley may have additional cases, but at least I have reviewed those on the issue of attempting to operate. So knowing that, counsel, how do you wish to proceed? Ms.
Your
McCoy,
Honor,
witness?
yes, I would like to call Officer Beaker.
Okay, Mr. Officer Beaker, I need you to raise your right hand. I'm going to need to administer 2 oaths to you. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Do you submit to the jurisdiction of the state of Kansas and of the United States of America for purposes of your testimony today, including but not limited to an action for perjury arising out of your testimony today?
Yes.
You can put your hand down. Court will find sufficient safeguards are in place to allow the officer to testify remotely. Ms. McCoy, you may examine.
Thank you. Officer Beaker, how are you currently employed?
Patrol officer with the City of Hayes.
And were you employed in that capacity on January 16th, 2023?
Yes.
And on January 16th, 2023, at approximately 1:45 a.m., did you come into contact with the petitioner, Branson Hoffman?
Yes.
And how did you come into contact with him?
I noticed a vehicle running in the parking lot behind the ARC thrift store. When I approached the vehicle to examine it further, I located Mr. Hoffman in the driver's seat, the vehicle running.
Okay, and you said that you noticed his vehicle. How did you come to notice his vehicle?
I was patrolling through the area. I saw the vehicle running, or at least saw that the lights were on behind the thrift store, which at that time was closed. So I circled back around, and that's when I approached the vehicle from behind, saw that the exhaust was coming out of it, so the vehicle was running.
Okay, and on January 16th, on that day, and at that time, do you recall what the weather was like?
It was a colder night. I don't remember any other inclement weather.
Okay. And you had mentioned that you had initially noticed it. Did you make a lap around, or what did you do before you noticed the vehicle?
I was driving eastbound on 6th Street. Noticed the vehicle parked back there in the parking lot, which the store was closed. So I came back through the alleyway and approached the vehicle from behind.
Okay. From the time that you circled back around, had the vehicle moved at all?
Not to my knowledge.
And when you noticed the vehicle, how was it parked?
It was parked facing east, up against the back side of the parking lot there.
Was it lawfully parked at that time?
It was in a private parking lot, so yes.
Okay. And how did you make contact with the driver?
Initially, I walked up. I could see that he was slumped over the center console of the vehicle. I knocked on the window to get his attention. He didn't really move. I could see that his eyes were open, and it looked like he was trying to mumble something. I was concerned for his safety, so I opened the driver's side door and started talking to him.
Okay. Were the windows rolled up or down at that point in time?
They were rolled up.
Okay. Did Mr. Hoffman have anything in his hands when you had approached him, like a phone or anything?
Not that I recall.
Okay. And so what did you do after you had opened the door? Were you able to have a conversation with him?
After several attempts, he was slurring his speech pretty bad and mumbling. I was able to somewhat communicate with him.
And through that communication, did you at any point ask if he had driven anywhere?
Yes.
And what was his response?
He replied yes.
And in asking that question, did you ask any follow-up questions as to did he drive there recently, what time, where he was coming from, anything like that?
No, I did not.
Is it fair to say he could have misunderstood your question when you had asked that?
Objection. Overruled.
I'm sorry, what was your response?
It's possible. I couldn't speak for him.
Sure. At that time, after he had mumbled yes, what did you do?
I asked him to step out of the vehicle to conduct testing.
Okay. At any point in time, did he indicate to you that he had, or make the statement that he had never left the parking lot?
No.
Okay, not that you heard at least.
No.
Okay. Did he say where he was coming from when, in response to your question, if he drove there?
Yes, he replied that he was coming from I had asked him if he was coming from Toby Jugs, or had drove from Toby Jugs to where he was, and that's when he had replied yes.
Okay, so would you be able to, so you were asked, were you coming from Toby Jugs? And he said yes.
Correct.
That's how you phrased that question?
I don't remember the exact verbiage I used, but I asked if he had drove from Toby Jugs to where he was at.
Now, I'm a little uncertain about what the cop's saying because I scoped out Toby Jugs' Facebook page and it looks like that place is hopping on the weekends. So I'm pretty sure that their parking lot fills up And the next closest place to park is going to be behind that thrift store unless you're going to cross one of those streets. So, if he gets there a little late because he had to do his hair and stuff, he'd have to go to the overflow parking lot behind the thrift store, which the cop probably knew. But when you ask a drunk guy, hey, did you drive here? He'd probably say yeah, because he drove there earlier in the night. But now he has him on record saying, yeah, I drove. I don't know. I could be totally wrong too. Maybe he did drive from across the street. Who knows? I was trying to give the guy kudos for not drunk driving home.
Okay. Is that parking lot, that private parking lot where you came upon Mr. Hoffman, is that in close proximity to Toby Jugs?
Correct.
Okay. So he drove to that parking lot to go to Toby Jugs? Is that your understanding?
My understanding was he was drinking at Toby Jugs and drove the vehicle to the parking lot where I located him.
But you didn't ask any follow-up questions to determine that. That's just your understanding.
Based off the question I asked, yes, that was my understanding.
Okay. The question that you asked, did you drive there?
Correct.
Okay. And I apologize if this seems redundant. The parking lot where you found the petitioner, was that behind Toby Jugs? Were people parked to go in there?
It's catty corner. The thrift store and Toby Jugs are right next to each other, separated by an alleyway. There's no parking behind Toby Jugs. There's an apartment complex there. And the parking lot where I located him would have been directly south of where that apartment complex is.
Okay. And in your experience, do people commonly park there prior to entering that establishment?
No.
People don't do that?
Not that I've seen. Most of the time that parking lot's empty.
Okay. And are you aware of what time Toby Jugs closes their establishment?
2 a.m.
Okay. And you had made contact with Mr. Hoffman around 1:45 that morning? Okay. And so, and again, jumping forward, you had asked Mr. Hoffman to step out of the vehicle. What did you do after that?
I walked him through I conducted the standard field sobriety test with him.
Okay. Did he engage in those tests?
Yes.
And which tests did you have him participate in?
All the tests within the standard field sobriety test.
In which order did you ask him to participate in those?
The walk and turn, the one leg stand, HGN, and then I requested a preliminary breath test.
Okay. And what were the results of those tests?
On the walk and turn, he exhibited 6 clues. On the one leg stand, he exhibited 2 clues. On HGN, I saw 6 clues, and then he refused the preliminary breath test.
Okay. At any point in time, did you see Mr. Hoffman drive that vehicle?
Other than when he stepped on the gas as I was talking to him during my initial contact, no.
Okay. Did you see that you indicated you had not seen the vehicle move from the first time you noticed it to when you had circled back around?
Correct.
Okay. I don't have any further questions for this witness, Your Honor.
Bradley?
Thank you. I do want to just summarize and go over the indicators of possible impairment real quick. You indicated that he had difficulty communicating.
Correct.
And did you notice any bloodshot eyes?
Correct.
Okay. You said the standard field sobriety testing. That was a walk and turn in the one leg?
Correct.
Okay. Do you recall the details of those?
So, as I explained, the 6 clues on the walk and turn, are you wanting me to go into more details on that? Is that what you're asking?
Just from your narrative, I noticed some obscurities. How many steps did he take on the walk and turn?
For the walk and turn, he took approximately 15 steps and then he stopped. And as I typically do, I just reminded him, once you start the test, continue until you're finished. And then he continued walking. He took approximately 30 steps. He about ran into the patrol car of my fellow officer that had arrived to back me up. So at that point in time, I asked him to stop just for his safety, and then moved on to the one leg stand.
And how many steps did he take for the one leg stand?
On the one leg stand, which, as I explained the instructions, you're supposed to stand there on one leg. He raised his leg up, similar to doing like a high knee, took a step forward, did that about 5 times, counting as I had instructed him to.
Okay. Did you ask him if he did consume alcohol?
Yes.
Okay. How did he answer?
He replied he had.
Okay. And you noted the odor?
Correct.
Was that coming from the vehicle or from the car? Or from the person? Sorry.
Both. I could smell it when I made my initial contact, and then as we were talking outside the vehicle, I could still smell the odor coming from it.
Okay. Let's move over to operation. So initially this was a safety check, correct?
Correct.
Okay. You said he was in the vehicle, non-responsive. After you opened the door, what did you first ask?
I'd asked him if he had been drinking any alcohol, just given the fact of the demeanor of him, based on my training experience, seemed like he was possibly intoxicated.
Okay. Oh, and next you asked where he was coming from, or if he came from Toby?
I had asked if he had drove from Toby Judge to the parking lot.
Okay. And then you asked for his license?
Correct.
Was he able to present that?
Eventually. He handed me several other items before I assisted him in locating his driver's license.
Could you go into more detail about what he was doing, process, anything he may have accidentally bumped?
So while he was grabbing for his driver's license, he pushed on the gas pedal, revving up the engine. I had asked him to take his foot off the pedal, and then that's when he handed me the other items.
Okay. What did he hand you?
Handed me a bank card and then some other piece of paper.
Okay. And you said you were able to see the license from his...
Correct.
Okay.
I could see where it was located in his wallet and pointed it out to him.
Okay. And then after all this, you indicated that he was arrested, and did you request a evidentiary breath test?
Correct.
And what was his response?
He refused.
Okay. And so on the DC-27, you indicated that he was operating or attempting to operate?
Correct.
All right. I have nothing further.
Any redirect?
Just briefly, when you asked him if he had drove there from Toby Jugs, he responded yes. Am I understanding that correctly?
Correct.
And you had asked him if he had consumed any alcohol, and he responded yes.
Correct.
Did you have any follow-up questions with that, as in when he consumed that prior to driving from Toby Jugs to that parking lot?
Not that I recall.
Okay. So no follow-up questions were asked, or no further context was given after that question?
Not that I recall.
Okay. No further questions, Your Honor.
Any recross?
No, Your Honor.
Ms. McCoy, next witness.
I would call Branson Hoffman, Your Honor.
Mr. Hoffman, you're going to also need to raise your right hand. I'm going to administer 2 oaths to you. I need to see your right hand on the screen, please. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? You're on mute, I think, because I saw your lips move, but I didn't hear anything. Okay, you're still on mute.
Maybe it's just your audio is not coming through.
Yeah, your audio. Now it shows you're on mute. Before it did not. Okay, maybe you need to turn up your audio because.
Can you guys hear me?
Yeah, we can hear you now. We've got. All right, let's raise your right hand and we'll put you under oath. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Do you submit to the jurisdiction of the state of Kansas and of the United States of America for purposes of your testimony today, including but not limited to an action for perjury arising out of your testimony today?
I do.
You can put your hand down and Ms. McCoy, you may examine.
Can you please state your name?
Yes. Branson Hoffman.
And Mr. Hoffman, are you the petitioner in this matter today?
Yes.
And were you able to hear the testimony of Officer Beaker previously given in this hearing?
I was. Yes.
And Mr. Hoffman, do you recall the incident that we're referring to on January 16th, 2023?
I do.
And would you be able to walk me through kind of the incident that led up to your contact with Officer Beaker at approximately 1:44 a.m.?
Sure. That night was like I said, on January 16th. It was a Sunday night. I kind of, as we mentioned, did go to the Toby Jugs bar. It's one of those local bars kind of downtown in Hayes. I believe I arrived around 6:37 p.m. that night. I had some friends I was meeting up with, so I told them I would go, have a few drinks.
And I'm going to cut you off, sorry. When you arrived, where did you park?
Yeah, so I parked, I was about to park where I usually would. I have residential friends that live in those apartments right behind Toby Jugs, which is the same empty parking lot. I say empty because it typically is, behind Toby Jugs, kind of where that it is, that was mentioned prior. So the exact same spot that was mentioned by the officer.
Okay, so you arrived there at approximately 6:30 p.m. Did
Yes.
you, so then you entered the establishment and consumed alcohol at that time, is that correct?
That's correct. Yeah, between 6:30, 7:30, sometime prior to 8 p.m. that
Okay.
night.
After entering the establishment, did you move your vehicle at all?
I did not. The vehicle was there for, do the math, 4 or 5 straight hours. I was in the establishment. A couple other friends came by, way longer than we thought we would be. So we were there pretty much the entire night.
Okay.
Um,
And upon leaving the establishment, what did you do?
Okay, yeah, so as we were leaving, or as we were kind of finalizing the night, I had a few friends stay in the bar, whereas I was, ready to be done. Now, I knew I was not able to drive, so I did not. I went ahead and walked over to my car, and around that time, as I was walking, I said, I am not in the capacity to be driving, so I did not. I did not operate the vehicle. However, I knew I had to find a ride home. So what I did is I did sit in the vehicle, which was 22 degrees outside. I sat in there to wait and find someone to kind of reach out to, or wait for others inside the bar who could give me a ride.
Okay.
So
So at no point in time did you attempt to move your car, move it to a different location, back out of that spot at all?
Absolutely not.
Okay. And so at that point in time, did Officer Beaker come up to your vehicle?
Correct, he did.
Okay. And then you heard the testimony about how he had asked you if you had driven there. What was your understanding of that question?
Yes. So everything that Officer Beaker actually said, I would completely agree with. As far as the question, my responses to those. He did ask if I had drank that night. And I honestly said yes, I did. And I was from the Toby's bar about 100 yards away. So I did tell him yes. He also asked if I operated the vehicle or if I had driven to that parking spot. Without even thinking the context of that question, I immediately said, yes, I absolutely drove. This is where I usually would park. I did not understand that he might have meant. I was under the assumption that, 5 hours ago, as I was sober and not had anything to drink, I had driven that big park.
So to reiterate, you had not, entered the establishment, consumed alcohol, came back to your vehicle and drove it at any point in time after you had consumed alcohol.
Correct. The vehicle was simply a means to sit and find an alternative ride home, whether that meant finding an Uber or finding a friend who could give me a ride home when the bar closed in 10. Yeah.
Okay. I have no further questions for this witness, Your Honor.
Cross?
You said this was Sunday?
This was a Sunday night.
I don't think you can drink on Sunday.
I had to freeze this right here because look at the judge's face. That's a man who drinks while watching Sunday football. Just saying. So I pulled up the Kansas Department of Revenue's website, and you absolutely can drink on Sunday. Alcohol sales on Sunday are the exact same as they are Monday through Saturday, 6 a.m. to 2 p.m. There are no restrictions for alcoholic liquor or CMB, cereal malt beverages, for the state of Kansas.
The bar is open on Sunday. Yeah.
Oh, yeah.
Oh. Okay. The 16th was a Monday, but it may have been the crossover.
Well, because the event took place at 1:44 a.m. But Sunday night was the night of the majority of, seeing friends at the bar.
Gotcha. It answered everything, it seems, honestly. I have no further questions.
Good. Any follow-up to that, Ms. McCoy?
No, Your Honor.
All right. Any additional evidence from the petitioner?
No, Your Honor, not at this time.
Any evidence from respondent?
No, Your Honor.
Any closing argument?
Just briefly, Your Honor, our issue on appeal is that the officer did not have reasonable grounds or probable cause to believe that Branson Hoffman was operating or attempting to operate the vehicle while under the influence of drugs or alcohol. As Your Honor is aware, you referenced State v. Fish. That would be our primary basis for asking this action to be dismissed at this time. Officer Beaker and Mr. Hoffman's testimony both indicated that he was asked a very generic question of, did you drive here? My client stated that without really understanding the context of it, he assumed, did you drive here several hours prior? And so that's why he answered honestly, yes. My client states that he had no time left the parking lot. Officer Beaker testified that he did not witness Mr. Hoffman driving or attempting to operate the vehicle. Our request at this time, Your Honor, based off of Fish and based off the testimony provided today, that this action be dismissed against the petitioner.
Ms. Bradley, do you have any argument?
Yes, Your Honor. As you're aware from your research, probably that the statute just changed after Fish.
Correct. The statute was amended after the Fish decision came down to add the language attempt to operate.
Correct. And it's unfortunately the didactic change in difference in this case. Had he submitted to testing and refused or failed testing, we would have to prove actual operation, and this would likely be a different case. Because he refused to submit to testing, the officer only has to have reasonable grounds of attempt, and case law has been extremely clear that turning on the car is an attempt. And he took it a step further and pressed on the accelerator. Actually, I'm not sure if it was in your research or not, but we had a case, Jarmer, 2 weeks ago that up at the Supreme Court, they're deciding the fine line of actual operation. She was stuck in a ditch but never moved. So that'll be a fun one. However, I did look at a few unpublished cases that were extremely close. You looked at Darrow, and obviously in that case, she claimed that it wasn't her that turned on the vehicle, but still any manipulation of any part of the vehicle is going to be attempt. I would note that Millard versus Kansas Department of Revenue is 502 P3D664. That was extremely similar to this one, only he was in his driveway instead of a parking lot. No clues of actual prior operation, but you don't have to prove operation when it's an attempt. We do admire the honesty and thank the driver for the decision to not actually move and operate the vehicle.
Okay, well, the court read the administrative hearing officer's decision and understood that the main issue appeared to be the definition of attempt to operate. So I wanted to go back and see whether there'd been any new case law from what I understood. 81002A1 for a test refusal requires that the officer have reasonable grounds to believe the person was attempting to operate a vehicle. The person was under arrest or in custody. Law enforcement officer presented the person with an oral or written notice, and the person refused to submit. While we didn't have any testimony about the oral or written notice, nor any direct testimony about the individual being in custody, the petitioner didn't raise those. Had they been raised, this outcome might be different. But since it was limited to the definition of attempt to operate, the court would note that while when Fish was decided in 1980, the legislature then amended the statute, because prior to that, attempt to operate was not in the statute. So attempt to operate was added, then State v. Kendall came down, which is a 2002 case. Facts in Kendall were, that case it was the defendant was asleep, slumped over the wheel, the vehicle was running, and the court found that that was attempt to operate. Did not require any proof that the defendant placed the vehicle into operation any more than just starting it. As pointed out by Mr. Bradley, State v. Darrow is probably even closer in that case. The defendant in that case alleged that she was in the car with several others. The other driver of the car parked it, left it running, and they exited the vehicle. She then found herself behind the driver's seat, but that she had not even driven it there. But when the officer found her, she was asleep, slumped over the wheel, and the car was running. And the Supreme Court again affirmed that that was attempt to operate. And the court cited the Sprague case, which I can now cite because it's, while unpublished, cited by the Supreme Court as at least persuasive authority. And in that case, the officer found Sprague slumped over the steering wheel in the driver's seat in a truck parked on the side street with the engine running. And the only difference being in that case, the radio was playing loudly. In that case, Sprague said his cousin drove him from a local bar to that particular location. And again, he didn't know how he ended up behind the driver's seat, but did. And the court in Sprague found that was attempt to operate, and the Supreme Court held the same. Well, Mr. Hoffman, it's commendable if, and I have no reason to believe you didn't tell the truth today, that you didn't actually drive. You know, the bar didn't close for 15 more minutes. You could have stayed in the warmth of the bar with your cell phone and called for an Uber, called for a Lyft, or called for assistance. For some reason, maybe because of the amount of alcohol you drank, you made the choice to walk to your vehicle to do that, to find a ride. Unfortunately, under Kansas law, that's attempt to operate. And therefore, based on the cases that I have cited, Kendall, Darrow, Sprague, the court's going to find that the petitioner attempted to operate, that there were reasonable grounds for the officer to believe that, and the petition is denied.
That hearing occurred in October of 2023. Following that, Mr. Hoffman's counsel submitted a motion to reconsider, and in that motion, they said the petitioner shows the court that his counsel heard the court state that based upon case law applicable to the facts of this case, that there was reasonable grounds to believe that the petitioner was attempting to operate his motor vehicle while under the influence of drugs or alcohol. Upon further review of the materials, counsel for the petitioner suggests that the incorrect box was checked on the DC-27 form. Officer Beaker checked the box indicating that Mr. Hoffman was operating the vehicle under the influence of alcohol and or drugs, not the separate, distinct box indicating he was attempting to operate the vehicle while under the influence. The issue upon appeal was that there was no reasonable grounds to believe that the petitioner was actually operating the motor vehicle, that he was only attempting to operate. So the failure for the officer to mark the appropriate box, attempt to operate, not operate, demonstrates that the officer's certification was defective and that it should be dismissed. So now we have a hearing on this motion to reconsider.
Good morning, counsel. Are we ready to proceed?
Morning, Your Honor. I believe so.
Yes, Your Honor.
All right, court will call Branson Hoffman versus Kansas Department of Revenue, 23 CV 42. Announce appearances.
May it please the court, Your Honor, the petitioner appears in person with counsel Mackenzie McCoy.
Charles Bradley for defendant, Your Honor.
All right. This before the court on the plaintiff's motion requesting the court to reconsider its earlier decision. We had a trial on the case. The court has reviewed the journal entry. The court does not have access to the file. I noted that this trial occurred 2 days before the security incident, and my access to the file was through Odyssey, which I no longer have available. So I have not had an opportunity to review the file specifically to determine whether the DC-27 box that was checked was attempt to operate or operate. But I believe there was evidence of that, and I'll ask counsel, at least I need to know that benchmark. Did the officer check operate or did he check attempt to operate? Mr. Bradley, you submitted the DC-27 as part of the agency record. Do you know?
It is operate. Would you like me to email that to you real quick?
No, I'll take your word for it. And I think that's what Ms. McCoy referenced in her motion, but I didn't have that to verify. So it did list operate and not attempt to operate.
Correct.
And I believe the journal entry, which Mr. Bradley drafted after the trial, and I recollect from my notes, I ruled that the evidence showed the plaintiff attempted to operate, not that he operated. Correct? All right. So the argument Ms. McCoy is making is, Your Honor, you made an error because you made a finding that he attempted to operate, but the DC-27 was operate. And that is the crux of her argument, correct?
Yes, Your Honor.
And I've read both the motion and the response, and I have also, and have pulled up, so if you see me glancing at my other computer screen, it is the Braun versus, and I say Braun because I don't think he's an Ellis County Brown, but anyway, Braun versus Kansas Department of Revenue, and I've read that case and I have it pulled up here. So, Ms. McCoy, it's your request or motion, so any additional argument you want to make after I've asserted these announcements?
No, Your Honor, we would stand on the arguments contained in our motion.
All right, Mr. Bradley.
No further argument. However, I did actually find a closer case, well, remembered my closer case after submitting that, in Lane versus Kansas Department of Revenue, unfortunately unpublished. That was 417 P3D. Okay.
All right, let me, before I pull that up, and I should be able to get it on Westlaw here. One of the things that the Braun case said at the end, and it's what Mr. Bradley asserted, but I'm not sure it prevails on the argument, is that in Fish, it cites, Braun cites Fish, and it says in Fish, there was no evidence, either direct or circumstantial, that the defendant drove the vehicle after he became intoxicated. In this case, Braun, there is circumstantial evidence that Braun drove after consuming alcoholic beverages because no alcoholic beverage containers were found in or around Braun's vehicle. As such, there is no evidence that Braun became intoxicated at the location where his vehicle was found, and as a result, we find substantial competent evidence supports the trial court's finding that reasonable grounds existed to believe that Braun operated a motor vehicle. I made a specific factual finding that he attempted to operate, not that he operated. And I know, Mr. Bradley, you presented some evidence, at least to cover that. In other words, asserting that he may have parked his vehicle behind the a building next to Toby Jugg's bar and then moved it to the parking lot at the apartment complex where he was located, correct?
I believe so.
But I didn't make that specific finding because I don't believe that, but I'll let you, because that's what Braun says is that, well, even if, but the court, there was ample evidence that the plaintiff drove the vehicle because there were no alcohol, and it was found out in the country on a country road parked by the side. That's the Braun case. So I'm kind of, you can see where I'm going with this. So
I do. And that's why I wanted to point out the Lane case.
It's Lane,
Braun is nice because it does a civil, it does a nice summation of State v. Baker as it applies to KDR cases, but it is not on point. The Lane case that I had is far more on point. In that case, the court did end up finding that the person had operated. He left the bar, moved his truck a little bit, and parked it. Right. And the court did end up finding that there was operation, but it also said, because he made the same argument as they are here, that, well, I didn't operate it, I just parked it, fell asleep. But the appellate court held that they don't need to consider the argument because even if it was a good one, we note that the Supreme Court has never held that failure to properly check the boxes on the DC 27 form mandates suppression. Instead, the court has said that even if the form includes technical errors like not checking a particular box, the state can still prove reasonable grounds for requesting a breath test through the use of the completed DC 27, through competent testimony, or through a combination of the two. So effectively, on many of the checkboxes on there, it's not going to cause a prejudice, it's not going to cause harm, it's definitely not going to warrant suppression if it can be fixed or remedied through the testimony. And the officer's testimony definitely established that there was an attempt to operate. Now, if he had submitted to testing, we would dismiss this case because that requires an actual operation. But because he refused to submit to the evidentiary breath test, attempt or actual operation is sufficient. And the officers, even though he marked operation on the DC 27, attempt to operate is sufficient to admit the DC 27 in this case. Generally, the only cases that have been completely fatal on wrong checkboxes have been basically the Wall case, wherein if you mark failure instead of refusal and you don't attach any breath test results and you don't check 9 through 11, honestly, you really got to mess it up. But the Lane case is kind of the closest one that I could think of or find.
And I'm seeing that paragraph you just read.
Yeah. And admittedly, in that case, because of the way that he was parked and different things like that, they ended up holding that he did actually have circumstantial evidence of operation. But they kind of backed it up saying that even if he hadn't, we'd still hold the same way.
Okay. Ms. McCoy, do you want to address that? I'm looking at the Lane case. I know that this just got.
Sorry.
Your Honor, I would. I know that there was reference to testimony about the officer. However, there was also testimony by my client. And again, that you stated that you didn't make a finding that he had operated the vehicle. Even, I believe it's my client's testimony and was at both hearings that he never moved his car. He just sat in it to start it to warm up. That's, and I don't have the Lane case in front of me, so I can't for sure. But if it's competent testimony that can also provide the grounds for the affirm, there wasn't competent testimony in this case, Your Honor, and that would be my only response to that without having access to the Lane case at this point.
Well, I remember the testimony. I know that Mr. Bradley and the officer through Mr. Bradley's examination tried to present evidence that the plaintiff may have moved his vehicle from behind the ARC building or in that vicinity over to the apartment complex. And then, but the plaintiff testified that no, he knew people that lived in the apartment complex. He parked there to go to Toby Jugs, and I'll make a finding. Court finds that more persuasive. It doesn't make sense that he would go behind a building and move it a couple of 100 feet to another parking lot and then wait there. Now, I don't know why he didn't just call from Toby Jugs, walk out and get in an Uber and go home, but people that have been in bars sometimes don't do totally logical things. However, so I didn't find that he operated, and I still don't make that finding. What I'm going to find is that he attempted to operate as is noted in the journal entry. So Mr. Bradley is saying under the Lane case, even if he didn't check that box, because it was a refusal, it doesn't make any difference. Correct, Mr. Bradley?
Correct.
And Ms. McCoy says, Judge, I haven't had a chance to look at the case and I'd like an opportunity to do that. Correct?
That's correct, Your Honor.
All right. And so here's what we're going to do. I want to give the plaintiff full opportunity. And Mr. Bradley, I appreciate you giving us this case. Would have been nice if we'd all had it, and maybe just thought of it this morning getting ready. And that happens to me all the time. So I don't think you tried to sandbag anybody, but I do want to give Ms. McCoy an opportunity to at least review that. So I'm going to stand on my earlier findings. There was no evidence that the plaintiff operated, but there is evidence that he attempted to operate. The case law on that is clear. And the court will, on the record, note that the officer checked operate, not attempt to operate. So now, Ms. McCoy, I'll give you an opportunity to read Lane. And as noted, it is 417 P3rd 273, but that means it just shows up in a panel of unpublished cases. But it's 2018 WL 2170209. And I think if you use that in Westlaw, I know it'll pop up, or Lane, L-A-N-E versus Kansas Department of Revenue, because I pulled it up right after Mr. Bradley gave that citation. So I will, how much time do you need to review that and submit anything?
Miss McCoy filed her response a day or two later. She basically restated the same thing, that there was an attempt to operate, he didn't operate, the DC-27 form had the wrong box checked, and then she went on to review the Lane case and say that the Lane case was factually distinct from this case in several ways, and that there was actual evidence in the Lane case that Lane drove the vehicle, which is different from this case. So then they asked the court to reconsider based on the fact that the incorrect box was checked and there was no evidence that Mr. Hoffman was actually operating the vehicle. A new hearing was scheduled for February of 2024 to make a final ruling on the motion to reconsider.
So, court will call Brandon Hoffman versus Kansas Department of Revenue, 23 CV 42. Announce appearances.
May it please the court, Your Honor, Mackenzie McCoy on behalf of Branson Hoffman, who also appears via Zoom.
Charles Bradley for defendant.
Right. The court scheduled this hearing to announce its decision. We had an evidentiary hearing involving an appeal from the administrative law judge. During the hearing, the court made a finding that the petitioner had attempted to operate a motor vehicle as defined under Kansas law, and the petitioner's argument was that that box was not checked on the DC-27, and therefore the court shouldn't consider it, or the court should dismiss the case because of the failure to check the box. That basically sums up in as plain and short of terms as the court can. So the court went back and looked at the law cited by both parties. There are two unpublished opinions of the Kansas Court of Appeals that the court believes are very relevant because they're virtually on point. That's Braun versus Kansas Department of Revenue. That is not an Ellis County Brown or Braun, that is a Norton County case, which is 2003 WL 257564415, and the Lane versus KDR case, which is 2018 WL 2170209. While unpublished opinions are not binding on the district court, they are persuasive authority. But what's really important is both of those unpublished decisions cite the Kansas Supreme Court case of State v. Baker, 269 Kansas 383. And Ms. McCoy makes an argument that Baker doesn't apply because that dealt with the admissibility of the DC 27 rather than the administrative aspect. But in these Court of Appeals cases, they applied the logic of the Kansas Supreme Court in Baker to the circumstances in both of those KDR cases. And what happened in both Braun, I should say, and Lane is that in those cases, the officer checked the box that they had reasonable belief that the petitioner in those cases was attempting to operate a vehicle, but the officers in each case did not check the box that they operated a motor vehicle. But the courts during the review found that there was evidence of operation, even though the box wasn't checked. And so the end result of both of those cases were the administrative officer decision was upheld. And the reason is, if you look at the administrative hearing officer's form, as I did in this case, the form, the administrative hearing officer checks a box that says, makes a finding that they attempted to operate, or operated, covers both elements, which is what was done in this case. So a finding's been made on the record, either that the petitioner attempted to operate or operated based on the evidence. The court made a finding that the petitioner attempted to operate under the law, and therefore it was covered by the administrative hearing officer, and the administrative hearing officer properly considered that evidence under the decision of State v. Baker. End result is, while I understand and appreciate the petitioner's arguments regarding this issue, the law seems clear that in this case, I've made a finding that the petitioner attempted to operate a motor vehicle. That finding is consistent with the evidence, and it is consistent with the decision of the administrative hearing officer, and therefore the court will affirm the decision of the administrative hearing officers as it relates to the petition. Is that clear enough?
Yes, Your Honor.
Mr. Bradley?
Yes, Your Honor.
All right. Mr. Bradley, because you prevailed, I'm going to ask you to prepare the journal entry denying the motion to reconsider and reaffirming the court's earlier ruling based on the earlier citation the court made, as well as adopting and incorporating this morning's. All right?
Very good.
All right. Anything further?
I don't believe so, Your Honor.
Thank you, counsel. We'll be adjourned.
So ultimately he lost, which I kind of figured was going to happen. So lesson learned, don't sleep it off in your car. Take an Uber. Call a friend. Don't sleep it off in your car. And if you do sleep it off in your car, do it in the trunk, maybe the back seat, maybe put your keys, throw them somewhere. You won't be able to find them the next morning, but that's okay. You won't get a DUI. Do not ever start your car. while you're intoxicated. Don't start it. Don't even look at it. If you're going to drink, just hide your keys somewhere. Yeah, especially in Kansas. But the interesting thing is his license was suspended for several months right after this happened. Then his license was reinstated pending this appeal. Now it's been almost a year. In May it will be a year. I'm not even calculating those months. So I wonder if he gets credit for those initial months the way you would get credit for time served in jail, or if his 1 year suspension starts today and it's a whole another year from now. It's kind of interesting.